I'm here at Florida Levin Law School to prove what your professors are gagged as bar members against saying federal courts are a scam. I have 4 Supreme Court petitions that prove it. The first petition shows how Federal Rules of Civil Procedure 12b and 52a3 let judges dismiss cases and prevent appeals based on politics without needing real legal reasons. I ask courts for prospective relief from Florida law that lets government subvert due process with perjury. Does a state have to prosecute perjury that's cultivated by the prosecutor? Does the finder of fact have to consider that there's a reward and no penalty for state agenda perjury? Far from addressing this right to the mitigation of perjury, courts refused to even acknowledge my allegation and lied about what I filed. After the clerk signed for the FedEx delivery of this petition, it didn't appear in the docket. This next petition asked the Supreme Court to clarify when courts can ignore witnesses and accept facts straight from the executive branch. This is legal for Fourth Amendment activity, like street detentions. When a cop searches you in the street, courts accept whatever justification is put forward, even if it's contrary to what any actual witness said. You can't go into court as witness and dispute what courts imagine a cop might have imagined. But courts also immunized against witness in a speech viewpoint case. The government rewarded and abridged private speakers to say false things that glorify government and injure state targets. The court said that what the speaker said is true, but the court did this by inventing facts contrary to the only witness. Facts are true in court depending on whether government likes them. This hasn't yet appeared in the docket. The next 2 petitions, a district court immunized politicians regardless what they did by dismissing a case without even reading it. But the court confessed there could be something it didn't dismiss with prejudice for not even knowing what it was about. Then the appeals court refused to consider the appeals of the claims that were dismissed because there could be some claims that weren't dismissed, which were given leave to amend even if nobody ever specified what those claims were and they didn't exist. Then courts pretended the ruling on claims which didn't exist applied to the actual claims, to say the actual claims could never be appealed or amended and deny hearing in any venue. It doesn't matter if courts are referring to claims which don't exist or inventing facts contrary to witness. It doesn't matter if courts use scams to avoid applying law to fact. Complete nonsense is allowed in federal courts to get a politically convenient outcome.